Monday's arguments at the High Court involve state laws in Texas and Florida that increase transparency and accountability for big tech companies and could change how social media platforms operate going forward.
The logic that the social media companies are arguing for would say, if we host speech, then it's our right to decide what's on our platform and what's not. But that's not true for any other kind of common carrier.
The Texas case challenges a law banning social media companies from removing political content, even if that content contains hate speech. While the Florida case looks at a law making it illegal for platforms to ban current political candidates from social media.
Here in front of the court, the tech companies are claiming that when they decide to take your posts or content down, it's really their free speech and they have a right to do it. So the justices seemed a little bit incredulous about that.
Florida's Solicitor General argued that such sites gain popularity as bastions of free speech, but claimed the tides have changed.
They now say that they are in fact editors of their user speech, rather like a newspaper. They contend that they possess a broad First Amendment right to censor anything they host on their sites, even when doing so contradicts their own representations to consumers. But the design of the First Amendment is to prevent the suppression of speech, not to enable it.
Justice Sonia Sotomayor questioned if the Florida law is overly broad, raising concerns it would cover sites like Etsy and force them to sell products they don't want.
This is so broad. It's covering almost everything.
Justice Amy Coney Barrett raising similar concerns.
We're talking about the classic social media platforms, but it looks to me like it could cover Uber. It looks to me like it could cover just Google search engines, Amazon Web Service, and all of those things would look very different.
Paul Clement, the attorney representing NetChoice, warned of significant disruptions to social media content if the court sides with the states, cautioning that companies may only allow puppy dogs on their sites to avoid controversies.
Is it anything more than a euphemism for censorship?
If the government's doing it, then content moderation might be a euphemism for censorship. If a private party is doing it, content moderation is a euphemism for editorial discretion.
A decision from the court is expected in June. Abigail Robertson, CBN News.
This legal battle has been a long time coming. Gordon?
And it is about time, but I think it shouldn't be up to each individual state, because then you'll get a patchwork of varying laws. This is something that the Congress should take up. And the issue is, does the First Amendment cover what it was originally designed to cover, which is speech in the public square? Now, we don't assemble any longer in the public square. It used to be you'd stand on a stool and you'd shout just like they do every day still in Hyde Park in London. And that was the idea, that you would have a free exchange of ideas in a public space. Well, what are the public spaces in the internet age? They're absolutely not owned by the government, and it shouldn't be owned by the government. But on Instagram and on Facebook and on these other public platforms, should you have the right of free speech? That is something we have to wrestle with in our generation, because the public square has absolutely changed.